Good morning, everyone. Nice to meet you all, and thank you for joining today's webinar. I think with a topic that is highly relevant for all UK-based companies working with European partners. Today, we're talking about the future of data flows from the European Union to the United Kingdom and how UK businesses can prepare to a changing legal environment. We will here focus on the EU GDPR, and we have a bit of an outlook on the following year and the changing legal environment and the current developments. But before we start directly with this topic, please allow me to shortly introduce myself and us. Us, in this case, means the TÜV Süd, especially the TÜV Süd Data Protection Consulting Services. We're a consulting company mostly based in Germany with over a decade of experience in data protection advisory. And we're offering solutions like an external data protection officer, and always we'll have the approach of offering pragmatic and solution-oriented guidance to businesses, navigating the complexities of data protection compliance. And I'm sure some of you are already aware of the fact that there are quite a few complexities. And my name is Steffen Reimann, and I currently work as a product and customer manager here at TÜV Süd, but I do have a legal background and several years of experience as both an in-house data protection coordinator and as an external consultant. And mainly my work is focused on the EU GDPR and the German Federal Data Protection Act. But now, without further ado, we might want to look at the agenda and start directly with our webinar. We will just start with a short introduction why data protection compliance matters. We'll then shortly talk about the legal background and the GDPR requirements for third country data transfers. This is what we're going to focus on today. Afterwards, we'll have a quick look into the 2021 adequacy decision, a term if you're not familiar with it as of right now, you will be familiar with it at this point. It's very important. It's one of the key terms of today's webinar. And this look into the 2021 adequacy decision will be followed by a view of the current status and the question, what is to do if this adequacy ends? We'll then have a look at certain strategic recommendations of how UK businesses can prepare for the future. And we'll end this webinar with a Q&A. You can see this in the WebEx on your right corner of your screen. Feel free to ask any question anytime you want, but we will answer those at the end of the webinar and hopefully give you not just an insight into the current situation, but also provide you with a useful answer here and there. So let us have a quick look into the question why data protection matters. And for this, we might want to have a look at the importance of the trade between the United Kingdom and the European Union. In 2024 alone, the trade between the UK and the EU reached over £800 billion in combined exports and imports. The European Union remains the UK's largest trading partners, with services, particularly digital and customer-related ones, being a major component. And whenever, in this context, personal data is processed, we have to address the data protection law. We can have a look at both the UK data protection law and the European data protection law. It, of course, depends on the certain situation and the certain topic we're discussing by now. But what is important to remember is the processing of personal data is quite often the case because the term is rather broad, so the scope is rather wide, and even when you're using individual email addresses, storing certain personal data at a server, maybe in the UK or in the European Union, or simply use names in emails or whatever, this can be considered processing of personal data. So data protection law is basically always there whenever we're talking about trade. Whenever we're talking about modern business, where we have to take care of data protection. And whenever we have cross-border data transfers, meaning transfer from one region to another, we have to take into account certain specific of data protection frameworks, of the data protection frameworks of these regions. And today we're focusing of the specifics of the EU GDPR when it comes to data that is transferred from European companies into the UK. And this, as mentioned before, quite often the case if we're talking email addresses or names. In all of those cases, you need to ensure, as with your European counterpart, that the GDPR requirements are actually met. Of course, there are quite a bit of legal requirements that have to be met when we're talking about data protection. We're focusing now on certain specifics for data transfer alone. And for this, for those of you maybe not aware of the current setup and how it works, we have a quick overview of the EU GDPR and the legal framework here. And within the European Union and before Brexit, important date when it comes to this, also with transfers to the United Kingdom, this transfer of personal data cross-border was somewhat unproblematic. Of course, there were a few requirements that have to be met, but it didn't matter if it's it basically didn't matter too much if it's from one company in Germany to another company in Germany, or from one company in Germany to a French company. And prior to Brexit, it didn't matter if it was a company located in Berlin transferring data to a company located in London. But this changed after Brexit, because after Brexit, technically the UK was now classified as a so-called third country under the GDPR. And for data transfers to third countries, meaning non-EU or non-European Economic Area countries, the GDPR imposes specific requirements set out in Chapter 5 of the GDPR. We don't have to go into the legal specifics here, but to put it simply, the GDPR aims to ensure that the level of data protection in the EU is not undermined by transferring personal data to a third country where there isn't a similar level of data protection. And the Chapter 5 offers several legal mechanisms to ensure this. Most prominently, we're talking about adequacy decision. There's this term again. Appropriate safeguards, particularly so-called standard contractual clauses, SCCs, and binding corporate rules, BCRs. And then there are additional solutions for very specific situations. We can't go into detail when it comes to that, but those three: adequacy decision, appropriate safeguards, and binding corporate rules, and those are the three most important ones. And those rules and those mechanisms, they are not just legal technicalities, because they ensure that the fundamental rights of EU data subjects are protected, regardless of where their data travels all across the globe. But now, with that short introduction, given that Brexit happened quite a while ago, I think it is important to have a look on this setup between Brexit and today. And after the end of the Brexit transition period, during which the EU GDPR still applied directly in the UK, the European Commission adopted a so-called adequacy decision on June 28, 2021. And what this adequacy decision does is that it essentially states that the European Commission considers the level of data protection in the third country, here, the UK, to be essentially equivalent to that in the EU. Therefore, companies are basically free to transfer their data into this country. And for the UK, this absolutely made sense at the time, because the UK's data protection framework back in 2021 was based on two core elements, which was one, the UK GDPR, which is basically the European GDPR retained in domestic law under the European Union Withdrawal Act, and the Data Protection Act 2018. And this was introduced when the EU GDPR still directly applied in the UK. And it used to specify and limit certain GDPR provisions through available opening clauses in the EU GDPR. So consequently, the UK data protection law closely mirrored the EU data protection law. Therefore, it was only logically and unsurprising that the European Commission also concluded, yes, the UK ensures an adequate level of protection within the meaning of Article 45 GDPR. And the important thing is that obviously from an economical point of view, what did this mean for the businesses? What did this mean for companies? The adequacy decision significantly simplified operations because the UK was recognized as providing an equivalent level of data protection. Companies did not need to implement additional safeguards, especially standard contractual clauses, or they also did not have the need to conduct data transfer impact assessments. Instead, there was the adequacy decision, and personal data could basically flow freely and seamlessly from the EU to the UK, just like before Brexit. However, this adequacy was not granted indefinitely. Due to planned UK reforms in the local data protection laws, the decision was limited to a 4-year term and set to expire in June 27 of this year. So that was also quite a while ago by now. So the interesting question now is, where do we stand now? And to keep you calm, not much has changed just yet. The reason for that is pretty simple, because already on March 18 of this year, the European Commission adopted an extension of the existing adequacy decision. This extension grants the UK an adequacy status for an additional 6 months, meaning that the current legal regime will remain in place until the end of December 27 of this year. So currently, we can still rely on the adequacy decision. And this temporary extension was intended to give the Commission time to closely examine the UK's Data Protection and Digital Information Bill, now officially titled the Data Use and Access Act, short DUAA, which is basically the new UK data protection law. And this law was officially enacted with royal assent in June 25 after a lengthy and politically quite sensitive legislative process. And this DUAA introduces some fundamental reforms to the UK data protection law. Key highlights include something like a new lawful basis that the EU GDPR doesn't know with the recognized legitimate interests, with certain expanded provisions for scientific and research use of data, new rules when it comes to automated decision making, which is pretty important when we're talking about processing personal data with the help of AI tools. Also, a few new rules about third country data transfer from the UK into yet another third country. So there were quite a bit of changes. So these reforms obviously raised a few serious questions about whether the UK still meets the GDPR's high data protection standard. And surprisingly swiftly, the European Commission responded. Already on July 22, it published its draft for a new adequacy decision. And in this, they were evaluating the DUAA in detail, and the Commission concluded that the United Kingdom continues to ensure an adequate level of protection for personal data, even under its reformed legal framework. So that is a key sentence, and it's very important, and it is also a very, very good news for companies, but it is also very important to remember that a draft is not a decision. This draft is a draft only, and it does not provide legal certainty yet. And we now have to have a look what happens next, because as a next step, the European Commission reached out to the so-called European Data Protection Board for their opinion on the draft. And this European Data Protection Board, or short EDPB, is a very important player when it comes to data protection topics in the EU in general. Even though the opinion of this board is not legally binding, another important thing to remember, their opinion is regarded as highly important and will have an effect on a lot of key stakeholders when it comes to the question whether or not the adequacy decision will finally be adopted. And historically speaking, the EDPB has a rather strict stance on EU data protection standards. So it was highly anticipated to hear what they would say about this draft, and if they have add something to this, or if they're going into the road of direct conflict with the European Commission, which they could do whenever they are of the opinion that the adequacy decision is not sufficient to secure the data subject's rights when we're talking about data transferred to the UK. And the EDPB had a thorough investigation of the draft and of the DUAA itself. And just about last week, it published its opinion. And in principle, and what they said here is, in principle, the EDPB basically welcomes the ongoing cooperation between the UK and the EU on a common data protection framework, which is nice to hear, but which doesn't also mean a lot. But more importantly, the board generally accept most of the changes to the data protection framework of the UK, and obviously with that, the accompanying adequacy decision draft. However, there are some things where they say there's still some aspects that require a detailed clarification. So it wasn't like they would agree right away with everything the Commission said, but they demanded the Commission to have a deeper research on a few of the regulations of the DUAA. And with that, what that obviously means is you had a look at it, but we're not fully convinced about your interpretation of the regulations of the DUAA, and therefore we're not fully convinced that you or that the level of data protection in the UK can be considered adequate to the European level. Unfortunately, we can't go into too much detail what these specifics are, and we hopefully we can wait, and the Commission will answer to this anyhow. But it concerns, among other things, the fact that the regulations that the DUAA provides for transfers from the UK to other third countries, and that those are a bit different from the European standard, and the EDPB states, and quite often quite loudly states, that it fears that further data transfer, so data from the EU to the UK and then from the UK to wherever, could undermine the EU's level of security and could pose a threat to the rights of the data subject. Another thing they saw a bit critical was that with the help of the new DUA, the Secretary of State's scope for maneuver in the United Kingdom has become a lot bigger, and especially when talking about recognized legitimate interests or with certain regulations with regard to automated decision making, there is a little bit of uncertainty because we see the law by now, but the Secretary of State's power can pose the threat that with the decision of the Secretary of State, the level of data security provided in the UK will be set lower, and therefore will undermine the EU's level of security. Meaning, from the look at the DUAA alone, you cannot just say, okay, this is essentially equivalent to the GDPR. You also have to take the Secretary of State's possibilities into account. So they are a bit critical, but they also offer sort of a golden bridge in the form that the possibility to solve some of the issues would be close monitoring of the behavior and the actions of the Secretary of State, for example. And and now the ball is back in the field of the EU Commission, who basically have to address the issues raised by the EDPB, but who have also shown, and that is of course only my personal point of view, certain tendency to maintain good economical relationships with important trade partners such as the UK. So, and there is still a chance, or there's still a very good chance that there will be an adequacy decision for the upcoming years. However, until a final decision is adopted, there still remains uncertainty. And should adequacy not be renewed, alternative safeguards will be required. And for most companies, the most accessible fallback mechanism remains the use of the SCCs, the standard contractual clauses I mentioned a few slides earlier. But those also mean that companies have to conduct something that is called a transfer impact assessment, or short TIA. And this assessment requires businesses to analyze the specific data they want to transfer into the UK and the legal framework in the destination country, so the UK, and whether it allows for adequate protection of data subjects' rights in this specific scenario. And quite obviously, this might create a challenge, because if the EU Commission comes to the conclusion that the level of data protection in the UK is not sufficient for the EU standards, a company can have a bit of a problem with, or it might become very difficult for a company to credibly argue that in their case and in their TIA, the data transfer is fine because the data is nonetheless secure, even if the European Commission said you can't do that. And that, of course, creates a challenge from an economic point of view, because obviously this could lead to blocked data flows, maybe to lost business opportunities, but most likely it will definitely result in increased costs of data transfers when we're talking about compliance in this regard. A study of the New Economics Foundation and the UCL European Institute suggests that failing to secure adequacy status would impose additional compliance costs on UK businesses of £1 to £1.6 billion. So that is a threat, and it will most likely will make things a bit more challenging. But I'm not trying to sound too alarming here. This is all still hypothetical. However, preparation might be key to be prepared for every scenario imaginable. So now the question is, how should companies act right now? And one thing, obviously, that now basically everyone is doing who is in data protection law and has cross-border data transfers from the EU to the UK is monitoring the adequacy status closely and monitoring the European Commission, the European Data Protection Board, important political stakeholders, because the decision-making process is still ongoing. And even though the draft from the Commission is a strong and encouraging signal, as mentioned before, it does not yet guarantee that a renewed adequacy decision will be adopted. However, I do believe that there is certain political interest when it comes to a new adequacy decision. But ongoing monitoring is essential to ensure timely responses to regulatory changes. So it's always useful to stay up to date when it comes to this. The next thing that is always useful and always very important from a data protection point of view is the mapping of data flows. It is a measure that we basically recommend to every company we're working with. You need to know where your data is flowing, from where to where, who has access to all of this. You need to understand where data is coming from. And it sounds obviously, it sounds obvious, and it is a reasonable thing to do, but more often than not, we see that companies in their daily business just lose oversight when it comes to the data flows. And now, in this case, it can become especially important whenever your company basically receives personal data from EU-based entities. There might be compliance risks in the future, as mentioned before. And only if you understand where you have high-risk areas, you might be able to prepare fallback options, especially when we're talking about a delayed adequacy decision or an ultimately rejected adequacy decision. Because what we see in our daily business is that companies that have a deeper look into the data flows will realize a thing or two about those, and therefore might be already able to reduce those data flows. For example, to put it simple, maybe there's a data flow from the EU to the UK that is simply not necessary. That, of course, is the easiest example. But if there's a data flow that is not necessary, just stopping this makes life so much easier. And maybe sometimes we have it a bit more, where it gets a bit more complicated, but only a bit, when we're talking about data flow, where the data is important in the UK and the data flow therefore is important, but it is not important to have personal data flowing into the UK. So it might be, for example, important that a headquarter in the UK needs to know how many new customers an EU-based entity had over the course of the last half year. But what it does not need to know is who those customers exactly are. So a simple solution is just to provide the information, 22 new customers into the UK, and not 22 customers with names, Manuel Mustermann, email address, whatever. It sounds very simple and it sounds pretty obvious, but those are the easiest ways to prevent any data transfer happening and make life so much easier. Because if we have just a number, 22 new customers, and it is not possible to trace back any real individual behind this number, and it is not considered personal data. And if it's not considered personal data, all of the EU GDPR is not applicable. And to be honest, that makes life a bit easier. So what I mean with this is just ensure and just check your data flows and map them and understand them, and then you can properly prepare fallback options. There could also be those SCC, there could also be change of server storage locations. All of these are suitable measures. And a third step that is also very important is to communicate transparently with your clients and business partners in the European Union when it comes to this topic, because you're in this boat together, basically, and reassure them. It always helps to reassure them that your organization is actively monitoring developments and that you are taking appropriate precautionary measures, and assuming or under the assumption that both parties want to continue with the data transfer, which most of the time will be the case, to find a solution that works for both is key. And an open communication is the first step to this, because it builds trust and demonstrates accountability. That is just, it's more of a business than a legal measure, but it is nonetheless one of the key factors when it comes to successful data protection compliance, and therefore successfully ensuring that the data subject is adequately secured. Of course, it is important to remember that ensuring an compliant cross-border data transfer is only one aspect of broader EU GDPR compliance. Additional safeguards, robust internal procedures, and ongoing risk assessments remain essential if you want to ensure full GDPR compliance. Of course, partnering with a trusted legal and technical advisor can help you navigate both the strategic and operational aspects of compliance. So please do not hesitate to reach out to us. We're here to help. And maybe to demonstrate this, we might have a look at the question I've seen. There are a few. Let me quickly have a look in the chat. First of all, what fines can be imposed if data are transferred without any safeguard? Yes, that is, of course, a highly relevant question from a pure business point of view. In principle, such a transfer constitutes a violation which can be sanctioned with fines up to 20 million euros or up to, or up to 4% of the global annual turnover, whichever is higher. So those numbers are high. But what might be important to remember here is that these sanctions primarily target the data exporter. So we're talking about the EU entity here that is transferring data to a recipient in the UK. So as a UK recipient, and this fine, this particular fine most likely won't hit you directly. However, of course, if you want to work closely with the UK, with the EU-based entity that has this risk, working together and developing proper safeguards is very important, because they have a risk of being subject to a fine. And just maybe to be, but not once again, not to sound too alarming here, I want to be very honest with you. This, of course, is only my personal point of view, but I do not expect any supervisory authority to apply this maximum fine. In most cases, they won't do this. In fact, the supervisory authorities in Europe, and especially in Germany, are more often than not way better than their reputation. It is not, and quite honestly, often when we're dealing with authorities, we do have the feeling that their primary goal is not to sanctionize companies. Their primary goal is to ensure that data protection requirements are met. So they don't always use, or they rarely use the method of a fine. And if they use it, they don't use the maximum number here and the maximum fine of 20 million euros or 4% of the global annual turnover. But, however, the legal possibility certainly exists. And I hope with that I was able to answer your question. The next one was, are there any technical measures companies can take to minimize the risk? Just as mentioned before, a few very simple technical measures could consist of anonymization of data before it's getting transferred, or additionally, let's say, for example, we can change the server location. So maybe it is a technical solution to just change the server location from the UK to the European Union. With that, maybe there won't be any third country data transfer any longer. Therefore, you've already successfully minimized your risk. Obviously, technical security measures are always very important, not just when it comes to third country data transfer, but to data protection in general. And with that comes, of course, information security topics and the risk that your company might facing with that as well. So yeah, looking into technical measures is always a very important and very useful tool to reduce risks for your company in general. Yes, given the time, the next question, if a new adequacy decision is adopted, will it apply indefinitely? That is unlikely. As mentioned before, the EDPB already suggested close monitoring, and the European Commission already in its current draft said something similar as well. And the current draft already includes a sunset clause, which basically works just like the sunset clause we had at the 2021 adequacy decision. So this means that basically the adequacy status would only extend until December 27 of 2031. So we're talking about 6 years. And of course, one important thing to remember here is that this unfortunately does not mean that you're safe, that the data transfer is safe for the next 6 years, because it can be based on an adequacy decision. Obviously, only if this adequacy decision will be adopted, because past experience have shown that an adequacy decision can be subject to the European Court of Justice, to verdict of a European Court of Justice, and we had this experience in Europe before with this so-called privacy shield, which was an adequacy decision or a method similar to an adequacy decision for data transfer into the US. And we had the situation that the data protection activist named Max Schrems went to court because he said no, especially the surveillance authorities in the United States can have too much access on data of people in the US or of European data subjects. Therefore, this data transfer in the EU, even with a privacy shield, is not applicable anymore and is highly critical, and there is in fact no adequate level of data protection in the United States, and the European Court of Justice agreed with him. And from one day to the next, all the data transfer that was based on this privacy shield had to be based on different methods. And that was a situation that was incredibly difficult for a lot of companies, because obviously we had quite a bit of data transfers. We're using, I mean, whenever your company is using Windows software, Apple software, all of those tech giants, there's quite a lot of time there's data transfer to the US or AWS service and all of that. So that was a huge problem also, because we were in the situation that I mentioned before that could become an issue if adequacy ends with the UK as well. Namely that, yes, there still was the possibility of standard contractual clauses, but you couldn't justify that those would be are in fact sufficient to maintain a certain level of data protection. And for years, we had a very difficult situation with data transfers in the US, and there are, without naming names, obviously, there were quite a lot of companies in a status of incompliance when it came to this, because data transfer to the US was critical to them. So, long story short, the new adequacy decision, even if it comes, will not apply indefinitely, and it might end even sooner than you might wish to. That is just the reality of it. Once again, I don't want to alarm you, but that is just something you need to know about. Next question. We have the question, what data here includes? Personal data, product data, marketing data. Oh, my company registered in the UK but operate fully remotely worldwide. Will this rule also apply to us? Will the legal team inside the company take care of this issue? The term, maybe to say a few things here, personal data is a broad term, and it is both a broad term in the EU GDPR and in the UK GDPR, even after the changes of the DUAA. So what this means is any data that relates to a natural individual, to a natural person. So my name is Steffen Reimann, and that is considered personal data. My email address is steffen.reimann@tufsud.com. That is considered personal data. It wouldn't be considered personal data if we're not talking about a natural individual. If we're talking about an email address like info@tufsud.com, that is not personal data, because it can't be traced back to a natural person. But it's also, of course, data of your employees. It's data of your customers. It's data of potential partners, potential customers. So yes, most likely in your everyday work, you will processing personal data. Most likely you will have to care about data from, you most likely will have to care about the data protection requirements, including the UK GDPR and maybe the EU GDPR. EU GDPR will then become applicable to you and your company if you're either having like a business entity in the European Union, if you're processing personal data of people from the European Union. In those cases, even if your company is registered in the UK, as soon as you're processing personal data of people of the European Union, you're into the EU GDPR. So yes, this most likely will be applicable for your company as well. I mean, once again, it's not something to be too afraid of, but it is something that your legal team should have a look at, and where you should develop the appropriate measures required by the legal regulations. So the next question is regarding data flow mapping. Are there other parallel EU data law requirements which companies may be able to leverage to make this exercise easier or less costly? In other words, can they reuse work done, e.g. for Data Act readiness, or EHDS or AIAA? Well, I can't speak for Data Act readiness. That is obviously I'm pretty familiar. I'm familiar with, and yes, you can use the mapping procedures you made for the Data Act already, because in this you most likely had to ask yourself the question, well, this date that I have here, is this considered personal data, yes or no? Because obviously, depending on the question, the next question would be, am I allowed to give this data to this user or to that user? And if it's personal data and the user requesting the data is not the data to whom this personal data belongs, you're first of all in a bit of a pickle, because that is an annoying situation to be in. But it also means that you might not be legally allowed to provide this data, this personal data, to the user in this instance. So yes, you can use this exercise to make this, or you can use your experience from this to make this exercise a lot easier. And I want to be sure about this. The data mapping, of course, is very important. And the data mapping, of course, is very important, but it's not. But it's not a method that strictly is required by the EU GDPR law, but a method that is rather a practical approach to data protection compliance within your company. Meaning, you're a bit freer here. Of course, there are some certain requirements like a record of processing activities, but we're not going too much into detail here and then. But everywhere where you have the information, yes, I got this data from this person from this country, and this data we're processing in this or that way, and it goes to those people and in this country. If you have this information, that is already a huge step. And it's already very important, and it will help you at addressing potential possible problems arising in the future. I hope I was answering that fully. And then there's yet another question. How about Northern Ireland? Is this regarded EU region under the Windsor framework similar to EU Red Cybersecurity Regulation and EU CARA? Oh, I gotta admit, I'm not familiar with the Windsor framework. Obviously, Ireland, the Republic of Ireland, is European and therefore is considered EU region. Mr. Van Vossen, I'm afraid I got to get back to you on this topic. Because I can't give you an answer right now. I have to look deeper into the Red Cybersecurity Regulation, the EU CRA. I'm very sorry about that, but of course we will try to, if it's okay for you, we will try to reach out to you and help you with your question here and provide a useful answer. And then there's is another question. Will there be another update in December? When it comes, there will definitely be another update in December from the European Commission, because time's pushing. And of course, if you would be interested in it, we can see if we can arrange just another webinar on this topic and give you an update on the current development. that I think might be a possibility. There are also several other possibilities here. Maybe if we can process your email to provide you directly via information, then we can contact you directly with any update on this topic, because we already have customers to whom this is a very serious topic, and therefore we just have to deal with it, and we're closely monitoring this. And of course, if we can help you with that, I'm sure we will reach out to you, and we will maybe make another webinar on this as well. We will see if we can arrange it just in time, but we will do our best. All right. Okay, you can get back to me. Brilliant, Mr. One Person. Thanks a lot. And how and who will do the audit for GDPR? There is no authority who will do a GDPR audit and will automatically check you. There is the possibility, and that is maybe combined with the next question, there's a possibility to help your company get compliant with the data protection requirements. And that obviously is something that we as TÜV Süd can and will provide. Here, once again, of course, we can reach out to you and just openly talk about how we can help you. But one thing I need to inform you right away. If GDPR works as ISO 9001, which TÜV Süd could issue the certification? That is an important question, a question we can get, or which we get quite a lot. And the thing is, there is no certificate in the GDPR. There is no certificate providing compliance with the GDPR. It's a bit different than those ISO standards, ISO 9001, 27701 goes in the right direction, but it's still not the same. So, and there simply is no certification, but the best way to ensure compliance is in fact your company is simply to meet the requirements and to set up a data protection organization within your company, because that helps you the best. That is the method that has been proven to be the most efficient thing as well. And one thing here to understand is that data protection is, of course, rather a marathon than a sprint. So it takes a bit of time, but you can get, at the start, it might be a few to-dos. That's just the way it is. But at a certain point, you're getting into the next stage of basically monitoring the current setup and just make minor adjustments or ask yourself minor questions. So it is doable. It is time. It is not too time-consuming, and it's especially efficient with proven methods and proven experts. And of course, we can reach out to you in this regard, and we would love to, and just openly speak about how we could most likely help you. And yes, brilliant. So if you're okay with that, maybe we reach out to you afterwards just to openly talk about it. And with that, sorry, follow up. So the company can announce by itself that it is compliant with GDPR. Well, yes, it can announce it, but companies can announce quite a bit of compliance in general. If a company announces that it is compliant with GDPR, most likely some of the questioners, some of your customers will ask the question, how are you doing that? Maybe the authorities will ask the question, okay, so if you're compliant, how are you doing that? And then you are at the point where it really gets interesting. So the best way still maintains just trying to be as compliant as possible. And there are proven methods to achieve this goal. And yes, with that, thank you all for your time. I think we went a bit overboard. Yes, Mr. One person. Yeah, as mentioned before, maybe we try to set up another webinar when we have an update, or if there's going to be an extension. That is something we have to look into it. As mentioned before, we're really monitoring closely the situation, so we can give you an update on this topic regardless. There's something that we can offer. Yes, so we're trying to make a webinar possible as well. We'll see about that when and how we can do it. But with that, thank you a lot for your time. I hope you learned a thing or two about data protection and its importance when it comes to data transfer. And of course, feel free to reach out to us anytime, to me directly, via our website, or contact our sales office, and we're happy to help. Feel free to use my personal email here anytime. My consent is given to that. And yes, with that, thanks a lot, and have a great Tuesday, and goodbye. Thanks.